everyone, welcome back to another episode of Courts This Week, your go-to source for the latest legal updates presented by LiveLaw. I'm your host, Awstika Das. I'm a lawyer practicing in Delhi and I'm here to take you through and break down the most significant updates from the week. From the corridors of the Supreme Court to local judicial proceedings, I'll be providing you with clear and concise summaries that keep you informed and ahead of the curve. But remember, for a more in-depth understanding, do visit LiveLaw's website at www.livelaw.in. So let's get started. The Supreme Court has this week delivered a landmark ruling addressing the mental health crisis among students, especially in coaching hubs. The judgment arose from the tragic case of a 17-year-old NEET aspirant who died under suspicious circumstances after falling from her hostel terrace in Visakhapatnam while attending classes at Akash Baiju's Institute. Her father sought a CBI probe, arguing that the local investigation was inadequate. The Supreme Court agreed, transferring the case to the CBI, citing grave lapses by local police and institutional authorities. A bench of Justices Vikram Nath and Sandeep Mehta has also issued 15 detailed binding directions for all schools, colleges and coaching centers across India. These include mandatory registration of coaching centers, appointment of qualified mental health counselors, structured career guidance for students and parents, and banning batch segregation of public shaming based on academic performance. The court ordered that all institutions adopt a uniform mental health policy, conduct regular sensitization sessions for staff and parents, and establish zero tolerance mechanisms for harassment, bullying, or discrimination. Institutions must also maintain safe infrastructure such as tamper-proof ceiling fans and restricted access to rooftops, and display suicide prevention helplines prominently on campuses. District-level monitoring committees headed by district magistrates will now oversee compliance, while the union government has been directed to coordinate with states and file a compliance affidavit within 90 days. Special focus has been placed on coaching hubs like Kota, Jaipur and Hyderabad, which have witnessed disproportionately high suicide rates. The court observed that mental health forms an integral part of the right to life under Article 21 and emphasized that until appropriate legislation or regulatory frameworks are formed by competent authorities, these guidelines will remain in force to safeguard students' welfare. The Supreme Court this week directed petitioners objecting to the release of the controversial film Udaipur Files, Kanhaiya Lal Taylor murder to approach the Delhi High Court for urgent relief. The court is hearing two connected petitions, one filed by an accused in the Kanhaiya Lal murder case who claims the film would prejudice his right to a fair trial, and another filed by the filmmakers challenging a Delhi High Court order that had stayed the movie's release. For more context, last week a bench of Justices Surya Kant and Joy Malla Bagchi had adjourned the matter, noting that the centre was already reviewing the CBFC certification of the film. When the case was taken up this week, the objectors challenged the centre's revisional order, which had cleared the movie for release after 6 edits. Senior advocate Kapil Sibal, appearing for the petitioners seeking a stay, argued that releasing the film before their challenge is decided would effectively render the proceedings infructuous, meaning meaningless. On the other hand, senior advocate Gaurav Bhatia, representing the filmmakers, urged that the release not be delayed, relying on precedents such as the Kashmir Files and the Kerala story, where courts declined to interfere with films cleared by the CBFC. Ultimately, the bench declined to stay the release and instead directed that the Delhi High Court hear the matter on priority on Monday, that is July 28th. It also clarified that it had expressed no opinion on the merits of the case, leaving all issues open for the High Court's consideration. Shortly after the order, director Bharat Srinate announced that Udaipur Files will hit theatres worldwide on 8th August 2025. The Supreme Court this week stayed the precedential effect of the Bombay High Court judgment acquitting all 12 accused in the 2006 Mumbai train bombings, but clarified that the acquitted persons will not have to return to prison. The matter came up before a bench of Justices M.M. Sundaresh and N. Koteshwar Singh in response to an appeal filed by the state of Maharashtra. Solicitor General Tushar Mehta, appearing for the state, argued that the High Court's findings, particularly its observations on custodial torture and investigation under the Maharashtra Control of Organised Crime Act, or MCOCA, could affect several other ongoing terror trials. However, he clarified that the state was not seeking immediate custody of the acquitted persons. The bench agreed to issue notice on the appeal and stayed the judgment to the limited extent of its value as a precedent, meaning that it cannot be relied upon in other cases. The 7/11 Mumbai Blasts, one of the deadliest terror attacks on Indian soil, involved 7 bomb explosions in local trains, killing 189 people and injuring more than 800. While the trial court had convicted the accused, sentencing 5 of them to death, the High Court recently overturned those convictions, citing lack of reliable evidence and allegations of custodial torture. With this Supreme Court order, the legal battle over one of India's most high-profile terrorism cases continues, raising critical questions on investigation methods and wrongful prosecutions. This week, the Supreme Court issued notices to the Union government and all states on a precedential reference by President Draupadi Murmu under Article 143 of the Constitution. The reference seeks clarity on the powers of governors and the President under Articles 200 and 201, particularly regarding assent to state bills and whether courts can impose timelines for such decisions. A 5-judge constitution bench headed by Chief Justice B.R. Gavai and comprising Justices Surya Kant, Vikram Nath, P.S. Narasimha and A.S. Chandurkar listed the matter for detailed hearings in August. Attorney General R. Venkataramani will assist the court, while Solicitor General Tushar Mehta waived formal notice for the union. Senior advocates K.K. Venugopal for Kerala and P. Wilson for Tamil Nadu indicated their intention to challenge the maintainability of the reference, arguing that the issues raised are already addressed in the court's Tamil Nadu governor judgment. That judgment fixed a 3-month deadline for governors and the president to decide on pending bills and held that prolonged inaction amounts to deemed assent. It also triggered a political debate with former Vice President Jagdeep Dhankar criticizing the judiciary's use of Article 142 powers. The presidential reference now places before the court 14 key constitutional questions, including whether such timelines can be judicially mandated, whether the discretion of governors and the president is justiciable, and whether Article 142 allows substitution of constitutional functions. For a detailed analysis of this case and the constitutional questions raised in this presidential reference, visit LiveLaw's website at www.livelaw.in. The Supreme Court this week declined to entertain a plea challenging a sweeping media gag order in the sensational Dharmasthala burial case, advising the petitioner to approach the High Court instead. This controversy began when a sanitation worker alleged that between 1995 and 2014, he was instructed to secretly bury bodies of women and children near Karnataka's famous Dharmasthala temple. These shocking claims prompted an FIR and the constitution of a special investigation team. Following the allegations, a Bengaluru civil court granted an ex parte injunction on July 18th, restraining over 390 media outlets from publishing or broadcasting any allegedly defamatory content concerning the Dharmasthala temple, its Dharmadhikari, Virendra Hegade's family, or its management. The court also directed the takedown of over 8,800 URLs in a sweeping John Doe order. A YouTube channel called Third Eye challenged this before the Supreme Court, alleging abuse of the judicial process and suppression of press freedom, arguing the gag order was obtained through material misrepresentation, since the FIR did reference temple-linked entities. However, a bench led by Chief Justice B.R. Gavai, along with Justices K. Vinod Chandran and Joy Malla Bagchi, declined interference, noting that the petitioner should first approach the High Court. The Supreme Court this week declined to examine the legality of directives issued by the Uttar Pradesh and Uttarakhand governments requiring eateries along the Kanwar Yatra route to display QR codes that would enable people to access ownership details. Observing that the Yatra had already concluded or was nearing its end, a bench of Justices M.M. Sundaresh and N. Koteshwar Singh disposed of the plea without going into the merits of the challenge. However, the court made it clear that eateries must, in any case, display licenses and registration certificates is mandated by law. The petitioners, including Professor Apurvanand and activist Akar Patel, argued that the QR code requirement indirectly revealed the religious identity of food vendors, amounting to religious profiling and infringing upon the constitutional right to trade under Article 19(1)G, besides being violative of the principle of secularism. Senior advocate Abhishek Manu Singhvi contended that the move violated an earlier Supreme Court order and amounted to an unconstitutional assault on free trade and secular values. Defending the directive, senior advocate Mukul Rohatgi for Uttar Pradesh argued that it complied with FSSAI regulations and was necessary to prevent misrepresentation, citing past instances where eateries temporarily changed menus during the yatra, allegedly offending the religious sentiments of devotees. Senior advocate Huzaifa Ahmadi countered that, saying that in any case, eateries sold only vegetarian food, during the period in question as per local norms. At this point, Justice Sundaresh remarked that consumers should be able to exercise their choice with the knowledge of whether an establishment has always been vegetarian or has only temporarily altered its menu, observing, and I quote, "Customer is king." The court, however, has clarified that other issues raised by the petitioners were not examined and could be pursued before the High Court if they so desired. The Supreme Court this week raised serious concerns about investigating agencies summoning advocates over legal advice given to their clients and called for clear guidelines to safeguard privileged communications. This issue arose after outrage over the Enforcement Directorate issuing summons to senior advocates Arvind Dattar and Pratap Venugopal, which were later withdrawn following protests by the legal fraternity. A bench led by Chief Justice B.R. Gavai with Justices K. Vinod Chandran and N.V. Anjaria heard the suo motu case initiated after Gujarat police summoned a lawyer merely for representing an accused. The court noted that such actions have a chilling effect on the legal profession, with CJI Gavai remarking, and I quote, "Even if the advice is wrong, it is still privileged communication. How can a lawyer be summoned for that?" The Chief Justice emphasized that the independence of the bar is fundamental to justice delivery and cannot be undermined by investigative overreach. Senior Advocate Vikas Singh for the Supreme Court Bar Association cautioned against replicating foreign practices where lawyers have been targeted, while Attorney General R. Venkataramani supported the need for protection. However, Solicitor General Tushar Mehta said, and I quote, "Media narrative was being built against the ED, but the bench stressed its concern arose from direct experience in courts." This matter will now be heard on 29th July, with the court seeking detailed submissions from stakeholders before framing guidelines to ensure that advocates are not harassed for privileged client communications. Reaffirming the constitutional guarantee against custodial torture, the Supreme Court this week ordered a CBI probe into allegations of brutal torture of Police Constable Khurshid Ahmed Chauhan at the Joint Interrogation Center in Kupwara, Jammu and Kashmir. Chauhan alleged that he was illegally detained from 20th to 26th February 2023, during which he was inhumanly tortured, including mutilation of his private parts, by fellow police personnel. A bench of Justices Vikram Nath and Sandeep Mehta quashed the FIR registered against Chauhan under Section 309 IPC, attempted suicide, calling it a travesty of justice to prosecute a victim of custodial abuse. Justice Mehta, authoring the judgment, ordered the immediate arrest of those responsible and mandated the CBI to complete the investigation within 3 months. The court also directed an inquiry into systemic lapses at the JIC to determine whether institutionalized impunity contributed to such abuse. Significantly, the Supreme Court has awarded Chauhan 50 lakh in compensation, recognizing the violation of his fundamental rights and noting that such restitution is essential in cases of egregious custodial violence. The court observed that custodial abuse erodes public trust and undermines the rule of law, calling for accountability and structural reform. In a major setback for Byju's and its promoter Riju Ravindran, the Supreme Court this week upheld the National Company Law Appellate Tribunal's ruling that insolvency proceedings cannot be withdrawn without the consent of 90% of creditors once the Committee of Creditors is formed. The insolvency process against Think and Learn Private Limited, the parent company of Byju's, was initiated by the BCCI over unpaid dues for a jersey sponsorship contract. Following a settlement between the two, a withdrawal application was filed. The appellants argued that since the settlement was reached before the COC was formed, approval was unnecessary under Regulation 30A(1)A of the Insolvency and Bankruptcy Code. However, the Supreme Court, agreeing with NCLAT, held that the application for withdrawal was filed only on November 14th, 2024, after the COC had been constituted on August 21st, 2024, thereby triggering Regulation 30A(1)B, which mandates 90% COC approval. Another creditor, Glass Trust, opposed the withdrawal and highlighted correspondence indicating that BCCI itself had asked the resolution professional to wait for the Supreme Court's decision before proceeding. With the dismissal of the appeal, Byju's corporate insolvency resolution process will continue unless 90% of its creditors agree to withdraw, putting the embattled edtech giant under increased financial and operational scrutiny. The Bombay High Court this week rejected a petition by the Communist Party of India, Marxist, seeking permission to protest at Mumbai's Azad Maidan about the situation in Gaza, sharply criticizing the party's priorities. A bench of Justices Ravindra Ghuge and Gautam Ankhar remarked, and I quote, "Our country has several issues to deal with. You are looking at Gaza and Palestine. Why don't you do something for our own country?" Speaking for Gaza and Palestine is not patriotism. Senior advocate Mihir Desai, appearing for CPIM, argued that the party is actively engaged in domestic issues and regularly conducts health and education camps. However, the bench questioned why it was not instead protesting on local civic issues such as flooding, blocked drainage, and illegal parking. The judges further observed that the subject of the proposed protest falls squarely within the domain of the nation's foreign affairs and is best addressed by the Ministry of External Affairs. The bench also pointed out a procedural defect. The original protest application had been filed by the All India Peace and Solidarity Foundation and rejected by Mumbai Police, but CPIM had not filed an independent application before approaching the court. Following these observations and noting this procedural defect, the bench proceeded to dismiss the plea. A Vanessi Sessions Court this week set aside a magistrate's order dismissing a plea seeking registration of an FIR against leader of opposition Rahul Gandhi over his remarks on Sikhs during a September 2024 speech in the United States. Gandhi had reportedly questioned whether Sikhs feel safe wearing turbans or visiting gurudwaras in India, remarks that the complainant Nageshwar Mishra alleged were provocative and aimed at disturbing communal harmony. The magistrate had earlier dismissed the plea, citing the absence of prior sanction from the central government under Section 208 of the Bharatiya Nagarik Suraksha Sanhita or BNSS, since the alleged offence occurred abroad. However, the Sessions Court has now held that such sanction is required only after cognizance is taken and not at the inquiry stage. Relying on Supreme Court precedents such as Ajay Agarwal versus Union of India, the court remanded the matter back to the magistrate for a fresh hearing, directing that the plea be decided in accordance with law. This ruling revives the complaint against Gandhi, leaving it to the lower court to determine whether an FIR should now be registered. And that's a wrap for this week's Legal News Roundup. I'm your host Awstika Das, and it's been a pleasure bringing you this week's Legal News Roundup. Until next time, stay informed, stay engaged, and stay tuned to LiveLaw. Thank you for watching.